Good day, everyone. My name is Michael Dave Steven Luan, and I'm here today with Ms. Esrelyn Amparo, Ms. Hazel Suarez, and Mr. Neil Hechanova to discuss to you Philippine jurisprudence concerning Section 12 of the Bill of Rights, or those rights of a person under custodial investigation. Now, the provisions of the Bill of Rights will be discussed further and in details later as we tackle the cases. But for now, let us first define what does custodial investigation mean. So, according to jurisprudence, custodial investigation means the questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Now, how do we know that a person is being subjected to custodial investigation? A custodial investigation begins when there is no longer a general inquiry into an unsolved crime, and the investigation has started to focus on a particular person as a suspect, which is when a police investigator asks, interrogating, or he starts exacting a confession from the suspect in connection with an alleged offense. With that said, let us now dive deep on these cases decided by the Supreme Court concerning custodial investigation.
The first case will be that of People versus Macam. So this case is about the case of People versus Macam is a case of robbery with homicide. So the facts are as follows. On August 18, 1987, the accused Eduardo Macam, along with Antonio Cedro, Eugenio Cawilan Jr., and brothers Danilo and Ernesto Roque, went to the house of Benito Macam. Upon arrival, Eduardo entered the house of Benito, who then offered lunch to his nephew and his companions who were waiting outside. Next slide, please. After Eduardo and his companions had taken their lunch, Eduardo Macam suddenly grabbed the clutch bag of Benito and pulled out a gun, announcing a hold-up. They then started ransacking the place looking for valuables. Next slide, please. After ransacking the place, they then tied up the members of Benito Macam's household, namely Leticia Macam, Nilo Alcantara, Salvacion Herrera, and the children of Benito. The accused and his companions brought them to a room upstairs where Leticia Macam was killed, while Benito, Nilo Alcantara, and Salvacion Herrera were stabbed. The following day, Danilo Roque claimed that he and his brother Ernesto went to the factory of Eduardo Macam's father to collect the fare of 50 pesos from Eduardo. However, they were suddenly approached by the security guards of the factory, where they were mauled and was accused that they were involved in a robbery killing. Next slide, please. After that, a patrolman Lamsin, and his companions brought the brothers Danilo and Ernesto to the headquarters of the Quezon City Police Department for investigation and detention. The other accused, Eduardo Macam, Antonio Cedro, and Eugenio Cawilan Jr., were already in the jail of the Station Investigation Division. They were forced to admit to the robbery killing, but the brothers Danilo and Ernesto claimed that they did not have anything to do with the crime charged. Next slide, please. All of the accused were then brought to the Quezon City General Hospital before each of the surviving victims and was made to line up in handcuffs together with some policemen in civilian clothes for identification by the victims. So the issue in this case is whether the uncounseled identification by the witness during the police lineup were violative of the constitutional rights of the accused. The court held in this case that yes, the right to counsel attaches upon the start of an investigation, and it is therefore appropriate to extend the counsel guarantee to critical stages of prosecution even before the trial. The law enforcement machinery at present involves critical confrontations of the accused by the prosecution at pre-trial proceedings where the result might well settle the accused's fate and reduce the trial itself to a mere formality. It was also stated that a police lineup is considered a critical stage of the proceedings. Next slide, please. In addition to that, it was stated that after the start of the custodial investigation, any identification of an uncounseled accused made in a police lineup is inadmissible. This is particularly true in this case where the police officers first talked to the victims before the confrontation was held. The circumstances were such as to impart improper suggestions on the minds of the victims that they may lead to a mistaken identification. Appellants were handcuffed and had contusions on their faces.
Let us now discuss the case of People versus Judge Ison. Private respondent in this case was a ticket freight clerk of PAL or Philippine Airlines. He was involved in irregularities concerning sale of plane tickets. Now PAL informed him that they will be conducting an investigation um, because of the said irregularities. Now, on the day of the investigation, Ramos gave to his superior a handwritten note expressing his willingness to settle the irregularities charged against him in the amount of 76,000 pesos. Furthermore, in response to the question asked by PAL, the answers of Ramos, in effect, inter alia, had basically uh, he kind of admitted that he had not made a disclosure of the mention of those tickets mentioned in the audit team's findings, that the proceeds had been misused by him, and that although he planned on paying back the money, he had been prevented in doing so because of shame, and that he was willing to settle his obligation, and he even offered a compromise. However, no compromise agreement was reached nor was consummated. So, about 2 months later on, an information was filed against Felipe Ramos, charging him with the crime of estafa, to which he pleaded not guilty. Now, the evidence of the prosecution presented his statements and written admission. However, respondent Judge Ison um, did not admitted such as evidence because, according to the judge, uh, the accused was not reminded of his constitutional rights to remain silent and to have a counsel. Thus, a motion to reconsider was filed by the prosecution, but which was denied by the said respondent judge, hence this appeal. Now, the issue in this case is whether or not it was grave abuse of discretion for the respondent Judge Ison to have excluded as admissible evidence the said handwritten admission and statement made by Ramos. The Supreme Court said yes, that the judge the judge rendered with grave abuse of discretion. Hence, his order or decision was set aside and annulled. The Supreme Court, speaking to Justice Narvasa, declared that Felipe Ramos was not in any sense under custodial interrogation. Custodial interrogation, as defined by the court in this case, means the questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. In this case, Ramos had voluntarily answered questions posed to him on the first day of the administrative investigation and agreed that the proceeding should be recorded. It is clear from the facts that Ramos was not in any way uh, was not in any sense under custodial interrogation, as the term should be properly understood prior to and during administrative inquiry into the discovered irregularities in which he appeared to have had a hand. Hence, the constitutional right under custodial interrogation under Section 20 of the old 1973 Constitution, in this case, did not uh, therefore come into play, and thus Ramos' handwritten admission and statements cannot be excluded on the ground that his Miranda rights was not accorded to him. So, based on this reason, the Supreme Court ordered respondent judge to admit said evidence, the handwritten admission and the statements made by Ramos during the investigation. Also, it is important to note also that the Supreme Court declared in this case that a person suspected of having committed a crime and subsequently charged with its commission in court has the following rights in matter of testifying to or producing evidence. So, number one, before the case is filed in court or with the public prosecutor for preliminary investigation, but after having been taken into custody or otherwise deprived of liberty in some significant way, and on being interrogated by the police. So a person has the continuing right to remain silent and to counsel and to be informed thereof, not being subject to force, violence, threat, intimidation, or any other means which vitiates free will, and to have evidence obtained in violation of these rights rejected. And we also have number two about after the case is filed in court, the person has the right to refuse to be a witness. He also have the right not to have any prejudice whatsoever result to him by such refusal. Uh, and he also have the right to testify on his own behalf, subject to cross examination by the prosecution. And while testifying, a person has the right to refuse to answer a specific question which tends to incriminate him from some crime other than that which he is then prosecuted. I will now pass the floor to the next reporter.
So the next case is the people of the Philippines versus Ronilo Pinlac. In Makati's San Lorenzo village, two Japanese nationals live next to one another. Mechanical engineer Mr. Koji Sato rented a home at 32 Argila Street. Although he was living alone, he had a housekeeper named Irene Jandayan and a cook named Delia Marcelino. At that time, Delia Marcelino was on maternity leave and was about to give birth to a child who had frequently visited by her husband, Pinlac, at Mr. Sato's place. The residence rented by Sato was divided from Mr. Saiki Osamu's residence, house number 32 in the same street, by a short concrete wall. Sato left his home on April 7 at around 5 p.m. Jandayan, the housekeeper, also left the home at around 6:45 to start her day off and secured all the doors before leaving. The next morning, she went back to her employer's house. The doors to Sato's home were already unlocked when he got home at 11:30 p.m. He looked around the house carefully and found that some of his possessions were missing. After that, Sato reported the robbery to Makati Police Station and asked them to check over his house. The news of Osamu's passing reached Sato after the police investigators had already arrived at his home. Following that, investigators gathered information at Osamu's home and documented the crime scene. A kitchen knife was found in the living room, which served as the killer's weapon. Later, this was given to the PC Crime Laboratory for a chemical analysis. The slash screen wall near the rear door was visible to the investigators as they circled the house. Footprints were discovered in the backyard that matched the impression left by Pinlac's shoes. Evelyn Salomea, Osamu's maid, was also investigated. She admitted that she saw Pinlac enter Sato's home around 7 in the evening, though she did not see him leave after that, and that Jandayan is aware of Marcelino's address. Her two statements were presented as proof. The police then went to Marcelino's house in Taguig where they discovered Pinlac, and they invited him to the police station. According to Detective Sampson, who also testified, the murderer entered the home by removing the jalousies in the back, and the fingerprints were taken from the victim's home. Regarding this incident, policeman Malyari submitted his final report. The accused vehemently disputes the aforementioned findings of fact, that he never left the premises of his house, and defense witness Barcelino Heramis attested to this fact. That evening, as the accused and his kids were practicing their instruments, Heramis observed the accused's presence on the premises. The accused was then brought to the crime scene by the officers, where he was given instructions to relive how the incident was allegedly perpetrated. It was at this moment that the prints of the sole of accused shoes were all over the premises of Osamos and Sato's house. His lips and mouth suffered cuts and cracks as a result of the unbearable physical torture he endured while being forced to confess to the crimes alleged. This blood then seeped into his clothing and eventually into his shoes, which is why there are blood stains on them. The police officers never reported the blood stain in the accused's shoes before or after the arrest, despite the fact that they could have seen it readily. They only got his shoes when they were covered in blood that was dripping from the accused's lips and mouth as a result of the injuries the tormentors had caused. When the accused could no longer endure the 7 continuous hours of torture, he finally gave in to their demands and signed a prepared confession that he was not even permitted to read or have explained to him. The issue of the case is whether due process was observed during the custodial investigation of the accused. The ruling of the court is in negative. The authorities' failure to explain the nature of the charges against the accused without informing him of his constitutional right to counsel during the custodial investigation led the court to declare that the accused's constitutional rights were violated. In addition, the prosecution only offered the accused extrajudicial confession, which is not acceptable as evidence. The other evidence offered there is just circumstantial and open to refutation. The court additionally notes that the arresting officer has a responsibility to tell the subject of the grounds for the arrest and to provide him with a copy of the arrest warrant. He will be told of his constitutional rights to counsel and to silence, as well as the possibility of his statements being used against him. The individual who has been arrested has the right to contact anybody they wish, including their lawyer and family members, using the fastest available method, such as phone call, if that is possible, a letter, or a messenger. The arresting officer must make sure that this is done, as this is their obligation. No custodial investigation shall be conducted unless it be in the presence of counsel engaged by the person arrested, by any person on his behalf, or appointed by the court upon petition either of the detainee himself or by anyone in his behalf. The right to counsel may be waived, but the waiver shall not be valid unless made with the assistance of counsel. Any statement obtained in violation of the procedure herein laid down, whether exculpatory or inculpatory in whole or in part, shall be inadmissible in evidence. Also, the prosecution's evidence was unable to demonstrate adherence to these constitutional rights. On top of that, the accused did not receive legal counsel's assistance and his alleged waiver was executed without it. In the case files, the prosecution failed to adequately refute evidence indicating the accused was mistreated and tortured for 7 continuous hours before to signing the pre-written extrajudicial confession. It has not been proven that the petitioner or the person being accused is guilty beyond a reasonable doubt. Hence, the appellant is acquitted. Now let's proceed to the next case, the people of the Philippines versus Ramon Bolanos. The facts of the case, this deceased Oscar Pagdalian was found lying on an improvised bed covered in blood with stab wounds. According to the testimony of patrolmen Rolando Alcantara and Francisco Dayao, they proceeded to the crime scene at Marble Supply in Balagtas, Bulacan. When they inquired about the circumstances of the incident, they were told that the deceased had been out drinking the night before with 2 friends, one of whom was the accused, Ramon Bolanos, until the early hours of the next morning of June 23, 1990. The supporting testimony of Patrolman Francisco Dayo further stated that they boarded Ramon Bolanos and Claudio Magtibay on the police vehicle and brought them to the police station after discovering the deceased firearm on the chair where the accused appellant was allegedly sitting. Ramon Bolanos accordingly admitted that he killed the deceased Oscar Pagdalian because he was abusive. This statement of the accused was considered admissible by the trial court as evidence against the accused because it was given freely and before the investigation, and that the aforementioned facts unequivocally support a just and logical conclusion that the accused Ramon Bolanos killed the victim Oscar Pagdalian. Each of the case is whether the accused appellant was deprived of his constitutional right to counsel. The ruling of the court is in affirmative. The court ruled that the accused appellant was deprived of his constitutional right to counsel. In accordance with Article 3, Section 12 of the 1987 Constitution, the appellant should have been made aware of his constitutional rights, given that he was already the subject of a custodial investigation while riding in a police patrol jeep on the way to the police station where a formal inquiry might have been undertaken. Under Article 3, Section 12 of the 1987 Constitution, which explicitly provides any person under investigation for the commission of an offense shall have the right to remain silent and to have competent and independent, preferably of his own choice. If the person cannot afford the service of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary incommunicado, or other similar forms of detentions are prohibited. Any confession or admission obtained in violation of this or the preceding section shall be inadmissible in evidence against him. The law shall provide for penal and civil sanctions for violation of this section, as well as compensation and rehabilitation of victims of torture or similar practices and their families. Also, since the alleged oral admission of the appellant was made while they were traveling to the police station in a police vehicle, it was evidently established that it was made without the assistance of counsel. The court reversed the subject judgment under review in light of the clear requirements of the Constitution regarding the process by which a confession can be admitted in evidence, as well as the obvious fact that the purported confession obtained while the appellant was inside the police car served as the only justification for conviction, and that the appellant's guilt was not established beyond a reasonable doubt. Hence, constitutional rights of the accused appellant have been violated, and the appellant is acquitted.
For the case of People versus Andan, this is a case of rape with homicide. The facts are as follows. That on February 1994, Marian, a 20-year-old nursing student, left her home to go to her school dormitory in preparation for her upcoming final examinations. She was walking along their subdivision when the accused, Andan, invited her inside his house on the pretext that the blood pressure of his wife's grandmother should be taken. Marian agreed since the old woman was her distant relative. Marian did not know that nobody was inside the house. The accused then punched her in the abdomen, brought her to the kitchen, and raped her. After doing the carnal act, the accused dragged the unconscious girl to an old toilet at the back of the house and left her there until dark. Night came and the accused pulled Marian, who was still unconscious, to their backyard in an attempt to transfer her body to a vacant lot on the other side of the yard. When the girl moved, he hit her head with a piece of concrete block. He heard her moan and hit her again on the face, which resulted to her untimely death. Next slide, please. The following day, the body of Marian was discovered. She was naked from the chest down. Her gruesome death drew public attention, which prompted the then mayor to form a crack team of police officers to look for the criminal. The police team traced the accused in his parents' house. They took him aboard the patrol jeep and brought him to the police headquarters, where he was interrogated. He initially denied any knowledge regarding the girl's death. However, when the police confronted him about the pieces of evidence found, the accused relented and claimed that his neighbors were the ones who killed Marian. Next slide, please. The accused and his neighbors were then brought back to the police headquarters, where a physical examination was conducted among them. The accused was found to sustain multiple scratches on his neck, chest, and back, and a freshly healed wound along his index finger. Next slide, please. The mayor, Mayor Trinidad, arrived at the police headquarters and proceeded to the investigation room. Upon seeing the mayor, the accused approached him and requested that they talk privately. The mayor led the accused to the office of the chief of police, and there he broke down and confessed to the killing of Marian. The mayor first asked for a lawyer to assist the accused, but since no lawyer was available, he ordered the proceedings to be photographed and videotaped. In the presence of the mayor, the police representative, in the presence of the mayor, the police, representatives of the media, and the accused's own wife and son, he confessed his guilt. He disclosed how he killed Marian. However, upon arraignment, the accused pleaded not guilty. So the issue in this case is whether the extrajudicial confession of the accused towards the mayor, the police, the representatives of the media is inadmissible as it was done without the presence of a counsel. The Supreme Court held in the negative, stating that the confession of the accused to the mayor was not made in any response to any interrogation made by the latter. In fact, the mayor did not question the accused at all. No police authority ordered the accused to talk to the mayor. The mayor did not even know that the accused was going to confess his guilt to him. Next slide, please. It was further stated that when the accused talked with the mayor as a confidant and not as a law enforcement officer, his uncounseled confession to him did not violate his constitutional rights. Thus, it has been held that the constitutional procedures on custodial investigation do not apply to a spontaneous statement not elicited through questioning by the authorities. Furthermore, what the Constitution bars is the compulsory disclosure of the incriminating facts or confessions. The rights under Section 12 are guaranteed to preclude the slightest use of coercion by the state, as would lead the accused to admit something false and not to prevent him from freely and voluntarily telling the truth.
Now let us discuss the case of Navalo versus Sandigan Bayan. In this case, Navalo was being charged with the crime of malversation of public funds when he failed to account during an audit the amount of 16,483.62 and for failing as well to restitute despite demands by the office of the provincial auditor to the damage and prejudice of the government of the Philippines. Now, in his defense, Navalo actually said that the charge against him was motivated by a personal grudge on the part of the provincial auditor, Antonio Espino. On the 25th of January 1978, he said that he was summoned to appear in the said school when he saw Espino and Macasemo. The safe used by him and Maximo was already open and the cash was already taken out of the safe and was placed on the table. He did not see the actual counting of money and no actual audit of his accountability was made by Espino. Navalo signed, however, the cash count only because he was pressured by Macasimo who assured him that he would settle everything. The collection in 1976 reflected in the statement of accountability were not his. According to Navalo, those are from Macasimo who had unliquidated cash advances. Now, the petitioner pleaded not guilty and contended that he was deprived of his constitutional rights under Section 12, Article 3 of the 1987 Constitution. The issue in this case now is whether or not petitioner was under custodial investigation when he signed the certification paper, the certification prepared by the state auditing examiner. The Supreme Court held in the negative. According to Judge Vitug, um, under Section 12 of Article 3 of the 1987 Constitution, it is only invocable only when the accused is under custodial investigation, which jurisprudence has defined as any questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. A person under a normal audit examination is not under custodial investigation. An audit examiner himself can hardly be deemed as a law enforcement officer contemplated in the above rule. Thus, based on this reason, the Supreme Court declared that no rights under custodial investigation, as claimed by Navalo, was violated.
The second to the last case is People versus Lee. Next slide, please. In this case, at around the midnight of May 7, 1984, death cast its shadow over Boracay Island, an internationally known tourist spot famous for its powdery white sand beach. The island is accessible by and from Kalibo Aklan, and after a 1.5 hour trip, it can also be reached in 20 minutes by a pump boat from Barangay Katiklan. Katiklan has a small airfield which can service a small planes. Felled by a gunshot wound on the neck, which caused his death approximately 6 hours later, Christian Langel E. Felipe, a Swiss tourist who was vacationing in the island together with her sister and some friends. The following day, on May 8th, a police report was entered as an entry number 3904. In the police blotter, it was stated that on May 8th, Police Padilla reported to the substation with the living body of one Benny D with a caliber 38, the now made, as a suspect shooting incident at sitio Manok-Manok, Malay, Aklan. Um, Acting on the police report, Chief of Police Tambong prepared a complaint charging the accused Benny D, the owner of the Benny Bar situated in the island, with the crime of murder with the use of unlicensed firearm. The complaint was subscribed and sworn before a judge, Jaime Tonel, of the Municipal Circuit Court of Baruag Aklan. Next slide, please. The witness listed in that complaint, namely Bernadette Langel of Geneva, Switzerland, who is the victim of sister, and Ian Mulvey of England, who executed a separate sworn statements giving their respective version of the incident. Judge Tonel issued an order. In this order, it was stated that the court finds a probable cause that the crime has been committed and that the accused may be responsible thereof, that there was no warrant of arrest issued for the apprehension of the accused for the reason that he is already under the police custody before the filing of the complaint. The accused posted a bail, which was approved by the judge on the same day. Next slide, please. Testifying for the prosecution, Juan Wilson Tumaob, a resident in the area and a fisherman by occupation. According to him, there was an additional prosecution evidence to effect that in the early morning after the incident, the accused confessed orally to Rodolfo Padilla, the operator of the radio station on the island, and voluntarily surrendered the gun he had used in shooting the victim. The accused denied having made any oral confession alleging that he went to Padilla not to report the incident but to state that a boy in the bar had found a gun on the sand floor while cleaning, and that Padilla picked it up from the bar at the accused request. The accused argues that even he did not make such confession, the same would be inadmissible as an evidence. Next slide, please. The trial court found the testimony of defense witness enmeshed in the contradiction on material points, rejected the disclaimers they had made, accorded more credence to the prosecution version and, as previously stated, render judgment of convictions, hence this appeal. Next slide, please. The issue in this case, whether or not the lower court correct in saying that the constitutional procedure on custodial interrogation is not applicable in the instant case. Next slide, please. The court ruled in affirmative. The case history and the documentary evidence attest strongly to appellant's oral confession and voluntary surrender. Appellant's assertion that the gun had surrendered was merely found by a boy helper while cleaning the bar deserves no credence for it was it were so it would have been absurd for him to have placed himself under police custody in the early morning after the incident. The sworn complaint for murder with use of unlicensed firearm signed by the chief of police also attests to appellant's oral confession that the complaint forms part of the record of the proceeding before the Municipal Circuit Trial Court of Buruanga, Aklan, and it is a prima facie evidence of the facts stated therein. Next slide, please. The court also noted that the fact that appellant surrender is further borne out by the order of the Municipal Circuit Court, Judge Tonel, categorically reciting that no warrant of arrest is issued for the apprehension of the accused for the reason that he is already under the police custody before filing of the complaint. It would have been at the variance with ordinary voluntarily placed him um of him as a human behavior for the appellant to have under police custody absent any of a culpability of any offense. Contrary to the defense contention, the oral confession made by the accused to Padilla that he had shot a tourist and that the gun he had used in shooting the victim was in the bar which he wanted to surrender to the chief of police is a competent evidence against him. Thus, the declaration of the accused acknowledging his guilt of the offense charged may be given in the evidence against him. It may, in a sense, be also regarded as part of the res gete. Under this rule, any person otherwise as a competent evidence who heard the confession is competent to testify as to the substance of what he heard, if he heard and understood it at all. An oral confession need not be repeated verbatim, but in a such case, it must be given in a substance. Next slide, please. What was told by the accused to Padilla was a spontaneous statement not elicited through questioning, but it was given in an ordinary manner. No written confession was sought to be presented in evidence as a result of a formal custodial investigation. Thus, the trial court, therefore, cannot be held to have erred in holding that compliance with the constitutional procedure on custodial interrogation is not applicable in the instant case as the defense alleges. Thus, no written confession was sought to be presented in evidence as the result of a formal custodial investigation. Next slide, please. Um, the last case is People versus Alicando. Next slide, please. In this case, appellant was charged with a crime of rape with homicide with Casimay Penicilia, a minor, a 4-year-old girl, choking her with his right hand. The incident happened after the appellant drank a liquor. In the afternoon of June 12, 1994, the father of the victim was drinking in the house. Appellant joined them, but every now and then would take a leave and return. Luisa Ribada, who was also lives in the neighborhood, heard the crying of the victim. She approached the appellant's house and peeped through an opening between its floor and door. The sight shocked her. Appellant was naked. On top of the victim, his left hand choking her neck. She retreated to her house in fright. The father of the victim returned to the house in 8 o'clock in the evening. He did not find the victim. He and his wife searched for the child until 1 o'clock in the morning. But their effort was fruitless. They did not find the victim. Rebada was aware that Penicillas were looking for their daughter, but they did not tell that he knew where she was. Another neighbor, next slide please. Another neighbor, Leopoldo Santiago, went down from the house to answer call of nature. He discovered the lifeless body of the victim under his house. Her parents were informed, and so the police responded. At 9 in the morning, Revada suffered a change of heart. She informed the parents of the victim that the appellant committed the crime. Next slide, please. Um, Appellant was arrested and interrogated by PO3 Danilo Tan. He verbally confessed his guilt without the assistance of a counsel. On the basis of his uncounseled verbal confession and follow-up interrogations, the police came to know and recovered from appellant's house victim a green slipper, gold earrings, buri mat, a stained pillow, and a stained t-shirt, all of which were presented as evidence for the prosecution. At the trial court, it was found appellant guilty and sentenced him to death and be executed by putting the person under the sentence to death by electric chair or electrocution. As soon as the facilities provided by the Bureau of Prison, the method of carrying out the sentence shall be changed into gas poisoning. So the case before the court considered as a automatic review considering that the penalty imposed was a death penalty. Next slide, please. The issue in this case, whether or not the due process during the custodial investigation was accorded to the accused. Next slide, please. The court ruled in negative. The due process was not observed in the conduct of custodial investigation for the accused. Once the primary source is shown to have been unlawfully obtained, any secondary or derivative evidence derived from it is also inadmissible. Stated otherwise, illegally seized evidence is obtained as a direct result of an illegal act, whereas the fruit of the poisonous tree is the indirect result of the same illegal act. The fruit of the poisonous tree is at least once removed from the illegally seized evidence, but it is equally inadmissible. This rule is based on the principle that evidence illegally obtained by the state should not be used to gain other evidence because originally it is illegally obtained evidence taints all evidence subsequently obtained. Next slide, please. The burden to prove that the accused waived his right to remain silent and the right to counsel before making a confession under custodial interrogation rests with the prosecution. It is also the burden of the prosecution to show that the evidence derived from the confession is not tainted as fruit of the poisonous tree. The burden has been discharged by clear and convincing evidence. Indeed, under paragraph 1 of section 12 of article 3 of the Constitution provides only one mode of waiver that is the waiver must be in writing and in the presence of a counsel. But in the case at bar, the record shows that the prosecution utterly failed to discharge his burden. It matters that in the course of the hearing, the appellant failed to make a timely objection to the introduction of this constitutionally prescribed evidence. Thus, lack of the objection did not satisfy the heavy burden of proof that rested on the prosecution.
Now let us discuss Republic Act 7438. This is an act defining certain rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers, and providing penalties for violation therefore. Because of time constraints, we will just discuss the salient features of this law. We have Section 2, which provides for the rights of person arrested, detained, or under custodial investigation and the duties of public officers. Under Section 2A, any person arrested, detained, or under custodial investigation shall at all times be assisted by a counsel. Under Section 2B, any public officer or employee or anyone acting under his order or his place who arrests, detains, or investigates any person for the commission of an offense shall inform the latter in a language known and understood by him. Uh, Not all people can speak English. That's why he should uh, inform him in the language that he understands or dialect. So of his right to remain silent and to have a competent and independent counsel, preferably of his own choice, who shall at all times be allowed to confer privately with the person arrested, detained, or under custodial investigation. If such person cannot afford the services of his own counsel, he must be provided with a competent and independent counsel by the investigating officer. Now we have section 2C. The custodial investigation report shall be reduced in writing. It should be in writing by the investigating officer, provided that before such report is signed or thumb marked, if the person arrested or detained does not know how to read and write, it shall be read and adequately explained to him by his counsel or by the assisting counsel provided by the investigating officer in the language or dialect known to such arrested or detained person. Otherwise, such investigation report shall be null and void and no effect whatsoever. Next is one of the most important, which is any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing and signed by such person in the presence of his counsel, or in the latter's absence upon a valid waiver, and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. So, with that said, uh, rise the question: what are the requisites of admissible extrajudicial confession? Not all extrajudicial confession are illegal. It can be admissible, and it can be admissible. Here is the mnemonics: wives. So if it is made by a person arrested, detained, or under custodial investigation with the assistance and presence of his counsel, or in the latter's absence upon a valid waiver, and in the presence of any of the parents, elder brothers and sisters, his spouse, municipal mayor, the municipal judge, district school supervisor, or priest or minister of gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. It must also be in writing, it must be voluntary, it must be expressed, and it must be signed. Okay? Um, we also have Section 2E, which provides that any waiver by a person arrested or detained under the provision of Article 125 of the Revised Penal Code or under custodial investigation shall be in writing and signed by such person in the presence of his counsel. Otherwise, the waiver shall be null and void and of no effect. And lastly, we have Section 2F. But instead of discussing this, I want to go to the next paragraph, which actually expanded uh, the coverage of the right of a person under custodial investigation. Because now custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed without prejudice to the liability of the inviting officer for any violation of the law. Now let's move to Section 4 or the penalty clause. Basically, Section 4 punishes those who does not obey the provision of RA 7438, such as a public officer or employee may be punished if he or she did not follow the provision of this law. And also under Section 4B, any person who obstructs, prevents, or prohibits any lawyer or member of the family uh, of the arrested and detained may also be punished under the said law. With that said, that will be all for our report. Thank you for listening, and I hope you will have a blessed day. Thank you. God bless.